A victory the state never saw coming. The Ninth Circuit Court of Appeals accomplished something extraordinary without fanfare, without dominating headlines, and without the typical stalling tactics that have plagued Second Amendment litigation for years. A trio of judges delivered a ruling that shatters one of California's longest-standing and most calculated firearms restrictions. For decades, open carry existed merely as a ghost right in California. Residents could technically request permits in rural jurisdictions, yet populated regions issued none whatsoever. The response was always denial. The system was engineered to render open carry unattainable while evading the political fallout of an explicit prohibition. That framework just took a devastating blow. The litigation is bared against Bonta, and the judges determined that California's metropolitan open carry prohibition violates the Second Amendment as applied through the 14th. If you've tracked Bruin, Duncan, Wolford, or Himani, you recognize this decision fits within a broader transformation. Jurists are exhausting their rationales for defending contemporary constraints lacking historical parallels. This extends well past California's borders. The Ninth Circuit encompasses Hawaii, Washington, Oregon, Montana, Nevada, Idaho, Arizona, and Alaska. Precedents established in one territory can cascade throughout the circuit, influence parallel disputes, and ultimately reach the Supreme Court to define the Second Amendment's public scope. For firearm owners, this transcends minutia. It constitutes foundational jurisprudence, and foundational jurisprudence shapes the coming decade. Part 1. The dispute that ultimately resolved. Baird versus Bonta has navigated the judicial machinery for years. It contested a California scheme most Americans beyond state lines never realized existed. California statutes prohibit open carry in counties exceeding 200,000 inhabitants. This prohibition encompasses nearly every jurisdiction where residents actually reside, labor, and commute. In sparser counties, open carry remains theoretically permissible, contingent upon licenses the state has never granted. The complaint contended this constituted a prohibition masquerading as oversight, and post-Bruin, such disguised prohibitions face vulnerability unprecedented a decade prior. Pre-Bruin, states could assert they were managing rather than forbidding. Jurists could weigh competing interests, defer to elected bodies, or manufacture public safety exceptions. Post-Bruin, that pathway constricted. When oversight lacks historical precedent, it collapses. The Ninth Circuit distilled the matter to two essential inquiries. Does the Second Amendment safeguard open carry as protected activity? If affirmative, does any historical tradition forbid it in concentrated populations? Once the panel affirmed the first and negated the second, the prohibition could not survive. Significantly, the complainant personally advanced his petition to completion. Firearms rights litigation need not emerge from organized entities. Private citizens can transform the legal terrain. Part 2. Bruin provided the weaponry. Every firearm owner must grasp this element. Absent the Supreme Court's 2022 ruling in New York State Rifle and Pistol Association against Bruin, Baird likely fails. Under the previous means and scrutiny framework, California would contend that security, demographic concentration, and contemporary urban circumstances warrant open carry limitations. Jurists would balance these assertions against personal liberties, then conclude state interests prevail. Bruin eliminated that methodology. Presently, analysis commences and concludes with constitutional text and historical record. The panel implemented Bruin precisely as drafted. It examined founding-era materials, 19th century legislation, and early Reconstruction measures to ascertain whether open carry constraints existed during incorporation-relevant periods. They did not. What California offered as parallels proved excessively contemporary, policy-driven, and conjectural to qualify. Essential Bruin doctrines in operation. The obligation rests upon the state. Historical tradition signifies authentic historical tradition. Innovative modern constraints cannot be validated by contemporary policy considerations. Once the panel embraced this structure, California retained scarcely any argumentation. Part 3. The demographic stratagem collapses. California avoided an outright open carry prohibition. It employed a population cutoff. When your county surpassed 200,000 residents, the right vanished. This mechanism was crafted for judicial endurance. Pre-Bruin, lawmakers assumed assumed that preserving theoretical exercise pathways would prevent courts from deeming it a prohibition. Yet, under Bruin, population thresholds invited intensified examination. The panel sought historical practices where liberties expanded in agricultural regions, yet contracted in concentrated ones. None materialized in early America. Demographic density never served as a constitutional delimiter. States never treated Philadelphia, Boston, or New York as zones where arms spontaneously forfeited protection. Brief clarification. Population density fails as a historical limiting principle. The founding era contained concentrated urban centers. No parallel demonstrates rights diminishing as concentration increases for legal analysts. This significance lies in neutralizing one progressive regulatory innovation. Population-based thresholds appear in magazine prohibitions, carry regulations, zoning exclusions, and additional anti-firearm strategies. Should the Ninth Circuit now question that mechanism under Bruin, alternative tribunals may follow. Part 4. California's licensing scheme revealed. The panel executed something numerous firearm owners have desired courts undertake for generations. It exposed the licensing charade. California asserted rural counties permitted open carry permit applications, suggesting the right persisted. Yet the state conceded no documentation confirms any permit was ever granted. The panel appropriately acknowledged that a right existing solely in documentation constitutes no right whatsoever. Bruin foresees this maneuver. It explicitly cautions that states cannot employ licensing to strangle constitutional liberties through procedural mechanisms. Post-Baird, attorneys challenging concealed carry authorization systems in restrictive jurisdictions now possess additional Ninth Circuit precedent to invoke firearms rights implications. Licensing must be substantive, not hypothetical. An authorization framework without actual issuance is prohibition. Tribunals are finally prepared to declare this openly. Previously, litigation such as Young against Hawaii grappled with this issue. Baird resolves it. Part 5. One liberty does not negate its counterpart. California's alternative argument proved ingenious, yet flimsy. The state contended open carry could be prohibited because concealed carry remains available. Thus, citizens retained some avenue to bear arms. The panel dismissed this reasoning as fundamentally incompatible with Second Amendment text. The right to bear specifies no particular manner. Concealed and open constitute equally legitimate modalities. The state cannot eliminate one and assert the other suffices as replacement. This carries dual significance. Initially, multiple states have experimented with alternative right substitution tactics in contemporary firearms litigation. After Bruin facilitated concealed carry accessibility, certain legislatures attempted to restrict open carry under urban oversight justifications. Baird obstructs that avenue. Additionally, the opinion corresponds with historical record. Throughout the founding and Reconstruction periods, open carry prevailed and was occasionally favored because it distinguished lawful residents from concealed wrongdoers. The panel recognized this history and treated it as authoritative. Part 6. The Ninth Circuit's evolution. Anyone monitoring the Ninth Circuit throughout the previous decade understands this ruling didn't emerge unexpectedly. It resulted from gradual structural transformation within the circuit 2 decades prior. The Ninth once ranked as the most antagonistic federal appellate tribunal for firearm owners nationwide. Following Heller and McDonald, the circuit obstructed most Second Amendment litigation through interest balancing deference, doctrinal technicalities, and procedural postponements. Bruin altered the available legal instruments, yet judges remain significant and panels remain significant. Baird succeeded due to panel composition. Judge Van Dyke has emerged as the most significant Bruin-aligned subordinate jurist in Western jurisdictions. His dissents in Duncan against Bonta magazines, Rupp against Bonta rifles, and Miller against Bonta assault weapon prohibitions informed the Supreme Court precisely how California manipulated the system. Those dissents now operate as litigation templates throughout the circuit. Judge Lee concurred. That matters. It confirms post-Bruin alignment extends beyond a single jurist. Legal observers should identify the pattern. Bruin restructures doctrine. Specific judges implement it. Once implemented, state prohibitions deteriorate. Should California petition for en banc reconsideration, the question becomes whether the legacy Ninth Circuit majority retains sufficient votes to suppress these disputes post-2020. Judicial appointments render that increasingly uncertain, and California recognizes recognizes this. Part 7. And bank implications. California seldom accepts Second Amendment defeats. Quietly, the state's legal culture weaponizes delay. An bank review serves as the principal instrument. Following Duncan's 3-judge victory, California and the Ninth Circuit orchestrated en-banc rehearing that annihilated the initial triumph and reset litigation timelines for years. That maneuver operates less effectively post-Bruin because en-banc review must still apply identical tests. Should California petition en-banc in Baird, 3 probable scenarios emerge. First, en-banc accepts the panel is overturned or constrained, and the Supreme Court subsequently intervenes. This scenario postpones implementation, yet elevates probability that the Supreme Court utilizes Baird as an open carry vehicle. Second, en-banc declines, the panel ruling stands, open carry licensing must materialize in California, and immediate district court injunctions may follow. Third, en-banc stalls, the court accepts rehearing yet postpones for months or years, while alternative Second Amendment disputes mature. This tactic preserves the prohibition absent definitive resolution. Firearm owners must comprehend California need not prevail to sustain its policy, merely delay the mandate. The Ninth Circuit engages extended strategic play, yet the Supreme Court now monitors that play more attentively. Part 8. Supreme Court considerations. The paramount strategic question underlying Baird concerns whether the Supreme Court seeks a straightforward open carry dispute. Bruin addressed concealed carry licensing. Young against Hawaii addressed open carry, yet failed procedurally. Multiple circuits have avoided generating direct circuit splits regarding open carry because they prefer not becoming the vehicle the Supreme Court employs to expand the right. Baird alters this calculation. A Ninth Circuit opinion striking a metropolitan open carry prohibition establishes 3 national trajectories. States with concealed-only frameworks lose justification. Population-based patches become constitutionally indefensible. Open carry becomes the default right when states constrain concealed carry. The Supreme Court historically awaits clean posture. Baird now supplies that posture. Should California refuse compliance, petitions will reach Washington sooner than anticipated. And should the Supreme Court grant certiorari, the ruling would apply nationally and immediately. Much as with Bruin, effects would prove concrete rather than theoretical. They would prompt statutory rewrites across numerous states overnight. Part 9. Affected jurisdictions. Those outside California frequently underestimate the Ninth Circuit's geographic scope. Western firearms policy functions regionally, not isolationally. Once the Ninth establishes a Second Amendment principle, these states must respond. Washington, Oregon, Hawaii, Nevada, Arizona, Idaho, Montana, Alaska. Some already favor firearm rights, others do not. Washington and Oregon, presently advancing aggressive firearms prohibitions through bans, assault weapon proposals, and restrictive carry regulations, cannot disregard Baird. Hawaii, post-Young and post-Bruin, has already been compelled to abandon some of its most rigid frameworks. A Ninth Circuit open carry mandate would eliminate the final legal fiction. Those states employ the notion that concealed carry constitutes permission rather than right. For national organizations, Baird serves as recruitment material for firearm retailers. It poses operational questions for anti-firearm legislatures. It delivers strategic warning. Once one right materializes in one state, neighboring states forfeit capacity to dismiss it as theoretical. Part 10. California's remaining options. California retains 3 strategic mechanisms: delay through en-banc petitions, mandate stays, injunction stays, and district-level obstruction. Revision: restructuring open carry statutes to resemble shall-issue concealed frameworks while imposing substantial fees, fingerprinting, and bureaucratic obstacles. Reframing: arguing that public safety concerns in concentrated urban centers warrant distinct regulations. Under Bruin's analog test, least likely to succeed, the state's political culture will prioritize delay initially. Delay permits legislative revision and novel litigation fronts before the Supreme Court can intervene. It additionally provides anti-firearm states opportunity to coordinate messaging and submit amicus briefs for future review. Firearm owners must not underestimate California's capacity to weaponize bureaucracy. A judicial triumph does not automatically translate to practical triumph. The state's objective is transforming Baird into a paper victory without actual public carry. A door has opened. Not every Second Amendment conflict resembles a magazine prohibition or assault weapon prohibition. Some prove subtler, some procedural, some reshape the battlefield before observers notice. Baird versus Bonta represents such a dispute. The Ninth Circuit didn't merely overturn a policy. It overturned a legal presumption that states may offer concealed carry while prohibiting open carry, claiming the right survives intact. Whether the ruling becomes mandate or Supreme Court vehicle, one truth surfaced today. The Second Amendment is not a select-your-method entitlement. It is a right to bear arms, period. Firearm owners have witnessed this previously. Heller deciphered the code. McDonald nationalized it. Bruin operationalized it. Baird activates it in public carry. Subsequent developments determine whether California's framework collapses or adapts. And, as ever, California developments seldom remain confined there. Should you wish to anticipate forthcoming developments, the en-banc petitions, the mandates, the injunctions, the Supreme Court angles, and the repercussions across Western states, make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.